everyone, my name is Yulia Vichart and I am a family lawyer. I work at the law company of a lawyer, Alexey Nikolaevich Skrябin. Our law company specializes in providing legal services in the field of marriage dissolution and recovery of alimony. Our lawyers provide support in court proceedings throughout Ukraine. In this video, I will tell you how to file a statement for divorce with a pregnant wife, whether a husband can divorce with a pregnant wife, how a divorce with the wife proceeds during pregnancy or before the child reaches 1 year old, how is a statement for divorce with a pregnant wife drawn up on the initiative of the wife. Watch this video till the end and learn a lot of interesting information about a divorce with a pregnant wife. Subscribe to my channel to receive up-to-date information in the field of family law. Contacts for contacting me about paid consultations are under this video. Apply for a divorce with a pregnant wife in Ukraine. The issue of divorce with a pregnant wife is currently very relevant. The divorce procedure in this case is regulated by the norms of the Family Code of Ukraine. Therefore, this code established restrictions on the possibility of filing a claim for divorce, namely with a pregnant wife and within 1 year after the birth of the child. According to the resolution of the Supreme Court of Ukraine, this restriction concerns both the husband and the wife, including cases when the child was born dead or died until reaching 1 year old. Exceptions to this rule are commitment by one of the spouses of an illegal act that contains signs of a criminal offense against the other spouse or child, recognition of the paternity of the child conceived by another person, exclusion of information about the father from the birth certificate of the child. It should be noted that the current norm is progressive, because according to the Code of Laws on Marriage and Family, recently only the husband didn't have the right, without the consent of his wife, to initiate a divorce case with his pregnant wife, and within 1 year after the birth of the child. Can a man to divorce with his pregnant wife in Ukraine? The procedure of divorcing of a husband with a pregnant wife is very delicate and requires certain knowledge in the field of jurisprudence. According to the Code of Civil Procedure of Ukraine, the husband's statement of claim for divorce with his pregnant wife is returned in cases when it is submitted during the wife's pregnancy or before the child reaches 1 year old without observing the requirements established by the Family Code of Ukraine. In such cases, the courts, in their decisions, return to the plaintiffs the statement for dissolution of marriage with a pregnant wife. Note that from the content of the application and the documents attached to it, it is seen that the married partners have a child under the age of 1 year, or when the claim was filed during the pregnancy of wife, and the evidence of unlawful behavior that contains signs of a crime, recognition of paternity by another person, or exclusion of the husband from the record of the birth of the child by the plaintiff is not attached to the statement of claim. Divorce with a wife in Ukraine during pregnancy or before the child reaches 1 year old. Divorce between spouses by common statement and mutual consent when the wife is pregnant or before the child reaches 1 year old requires close attention and a comprehensive consideration of the case. It should be noted that if the spouses agree on a divorce when the wife is pregnant, then they have the right to dissolve the marriage on the basis of the Family Code of Ukraine in the registry office. Comparing divorce in the order of a special and a claim proceeding, it should be taken into account that the restrictions of the Family Code of Ukraine relate precisely to filing a claim for divorce. Application for divorce with a pregnant woman on the initiative of the wife in Ukraine. Acknowledgement of the paternity of a child conceived by another person gives the wife the right to file a claim for divorce. One of the decisions states that the plaintiff at the time of the consideration of the case was pregnant with another man with whom she wanted to marry, and therefore she asked to break the marriage between her and the defendant. As seen from the notarized statement, this person confirms the fact that from a certain time he has been living in a de facto marriage relationship with the plaintiff, who is currently pregnant, and is the biological father of the unborn child. In opposite cases, the courts refer to the fact that though the statement of claim by the pregnant wife was filed during the pregnancy of the wife, there is no evidence that the paternity of the unborn child was recognized by another person in the materials of the claim, such as a statement is returned to the plaintiff. It is possible to resolve the issue when the father isn't the mother's husband, both in court and voluntarily. So, if a mother who is in a registered marriage at the state registration of birth declares that her husband isn't the father of this child, and in this regard asks not to indicate his father in the birth record, her requests can be satisfied only if there is a common statement of spouses about the non-recognition of the husband as the father of the child, as well as statements of the mother and father of the child about the recognition of paternity. Regarding the judicial procedure, the Family Code of Ukraine grants a person the right to challenge his paternity, namely to file a claim to exclude the record of him as a father from the record of the birth of child. In case of proof of the absence of consanguinity between the person recorded as the father of the child, the court makes a decision to exclude information about the person as the father of the child from the record of his birth. Considering divorce cases with the existence of a child under 1 year, the court certainly notes in the decision that, as in accordance with the child's birth certificates, not a party of the case but another man with whom the wife lives together is recorded as his father. Therefore, the existence of a child under 1 year, in this case, it isn't an obstacle to the consideration of the case and the dissolution of the marriage. Consulting a professional divorce lawyer is a guarantee of your success. Contact the lawyers of our company in any way convenient for you. Call or write to messengers. We will help you to resolve your issue quickly and efficiently. If you have a need for advice or paid services of a lawyer, then contact the contacts listed under this video. If you have any questions, then write them into the comments to this video and I will definitely answer you. If this video was useful for you and you learned something new about divorce with a pregnant wife, then like this video, subscribe to my channel, share with your friends, press the bell not to miss new videos. See you in new videos.